Ladies and gentlemen, welcome to the Civil Justice Subcommittee for March the 4th, 2026. Mr. Clerk, take the roll. Members, sign in and signify that you're here. Mr. Clerk, you recognized.
Mr. Chairman, you have 7 members present. You have a quorum.
All right, members, we got a quorum. Any personal orders? Seeing none, we got a couple things to take care of. Item number 10, House Bill 8, HJR 805, rolled 1 week. Next is item number 14, House Bill 1923, rolled 1 week. Next is House Bill 1949, rolled 1 week. We're going to go out of order and call item number 9, House Bill 2376 up. Chairman Doggett. We got a motion and a second. And Chairman Doggett, you are recognized. I don't show an amendment.
Good afternoon. Thank you, Mr. Chairman and committee. Currently, state law says that no person shall, and I'm paraphrasing here, carry a firearm into any building that is housing judicial proceedings. That's been the law for at least since I've been elected in the legislature. In some of our rural communities and our courthouses, we also not only have courts of law, but we have our tax assessor or our trustee or our clerks, county clerk, where you can get your car tags. And so the sheriff, my local sheriff, asked me about this last year, about putting in some type of storage facility so that an individual that comes in that is carrying a firearm can store that firearm before they enter the courthouse and not be in violation of the law. And so checking into that, we found that there is nothing that's in law that would allow a sheriff to be able to do that. Even if they desired to do so, it would still be in violation of state law. And so what this bill does is simply says that it is permissive for the sheriff to, or the county to install some type of storage facility at the courthouse for individuals that are carrying firearms to store them before they enter the building.
Thank you, Chairman Doggett. Any questions for the sponsors? Seeing none, we're voting. All those in favor of sending House Bill 2376 to full judiciary signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, takes the roll. Or takes the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail.
Thank
Full
you all.
judiciary. Congratulations. Next up, item number 1, House Bill 734 by Chairman Hicks. We got a motion. Do we have a second? We got a second. Chairman Hicks, I do show an amendment. Would you like to add that?
Yes, sir, please.
What number do you show? We got a motion, and do we have a second? We got a second? Chairman?
Chairman, I show 012830.
That's what I show too, and we got a motion second. Any objection adding 12830 to House Bill 734? Seeing none, we're voting. All those in favor of adding the amendment signify by saying aye. Opposed, no. The amendment's added. And Chairman, you're recognized on the bill.
Thank you, Mr. Chairman. And that amendment just actually updated the effective date is all that was. The bill, House Bill 734, this bill deals with the 4-year statute of repose in construction defect cases. The U.S. Sixth Circuit Court of Appeals in a 2024 case has held that 4 years simply means 4 years. This bill would permit an additional necessary party to be brought into the case later if the initial lawsuit was timely filed within the 4-year statute of repose. This bill, again, is an initiative of the Associated Builders and Contractors of the Greater Tennessee chapter. And with that, I stand to answer any questions.
Very good. And Representative Johnson, you're first on my list.
Yeah, and I heard you say 4 years is 4 years. So 4 years in one day, if you find a flaw in the foundation, it's too late. So why are we limiting people when a flaw might reveal itself later?
And just to note, y'all can go back and forth.
Okay, thank you very much. Well, I think it was The Sixth Circuit has been clear. So I guess that's just making sure that our law says what the Sixth Circuit. So I guess the better question would be, why did the Sixth Circuit think that? And so we just want to make sure that our law is clear. That's how the Sixth Circuit's going to look at this. It's going to be 4 years. Therefore, we need to be in line with what they're saying. And so that's why we're putting it at 4 years as well.
Well, we could still make it different if we wanted to, more protection for the people of the state, right?
Yes, we could. Absolutely, we could. But
Okay,
of course,
thank you.
Yeah.
All right, Representative Doug, or Garrett?
Thank you, Mr. Chairman. Chairman, thanks you for this piece of legislation to address the concerns when statute of repose means that an action is completely over with, right? And it can sometimes go beyond the regular statute of limitations. And in a design situation, if something doesn't happen over 4 years, there could be multiple reasons why something went wrong. One thing that the reason why this exists is to cut off, you wouldn't be able to afford insurance to provide coverage for something like this if there could be an action taken 15 years later of a particular bill when that 15 years nothing happened. So there's got to be some sort of cutoff. So I appreciate this piece of legislation that you brought. I'm certainly going to support it because of concerns that, also witnesses tend to disappear after 4 years. So it's a very hard thing to bring to court over a certain period of time. And certainly 4 years for something that was done wrong, something's going to happen between that time. So I appreciate the piece of legislation. Thank you very much for it.
Thank you, Representative Gary.
Thank you, members. We don't have anybody else on the list. We're voting to send House Bill 734 to judiciary. All those in favor vote aye. Those who vote no, opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, takes the vote.
Mr. Chairman, you have 6 ayes, 0 noes, 1 present not voting.
The ayes prevail. House Bill 734 goes to judiciary as amended.
Thank you, Mr. Chairman.
Thank you. Next up, item number 2, House Bill 1903 by Chairman Terry. Do I have a motion? We got a second. We got a second. And Chairman Terry, I do show an amendment.
Yes, sir.
Would you like to run that?
Yes, sir. Amendment number drafting code 014548.
That's what I showed. We got a motion and a second on the amendment. All those in favor of adding 14548 to House Bill 1903 signify by saying aye. Opposed, no. Amendment added. You're recognized on the bill as amended.
All right. Thank you, Chairman and Committee. And House Bill 1903 is an act to amend our code concerning the homestead exemptions. The bill addresses a gap in current Tennessee law by ensuring that upon the death of a head of household, the homestead exemption extends not only to a surviving spouse or minor child, but also to an adult child 18 years older who has a developmental or intellectual disability and continues to reside in the home. Currently, our homestead exemption statutes protect a surviving spouse and minor children, but they do not explicitly protect adult children with significant disabilities in the same way, and this corrects that omission. These vulnerable Tennesseans are eligible for ABLE accounts, and I appreciate the Treasurer's Office for bringing that to my attention. And so this bill and the amendment that y'all put on would allow these individuals to place these funds into an ABLE account to assist their needs as well, and I appreciate your support.
Good explanation. Any questions for the sponsors? Seeing none, we're voting to send House Bill 1903 to judiciary as amended. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 1903 goes to full judiciary as amended.
Thank you, Chairman and Committee.
Next up, item number 3, House Bill 1915 by Chairman Boyd. We got a motion. We got a second? Chairman Boyd, you are recognized, and I do not show any amendments.
Mr. Chairman, I'd like to roll House Bill 1915 2 weeks, please.
With objection, we probably want to do next week since next week's the final calendar.
We'll roll it to next week, Mr. Chairman.
With objection, next week. All right, next up, item number 4, House Bill 2112 by Chairman Boyd. Do we have a motion? We got a motion. Do we have a second? We got a second. I do show an amendment.
Mr. Chairman, I'm showing amendment drafting code 014329.
That's what I got. We have a motion and a second. All those in favor of adding 014329 to House Bill 2112 signify by saying aye. Those opposed, no. The amendment's added. You're recognized on the bill as amended.
Thank you, Mr. Chairman. And committee, so What this bill seeks to do, this will help our nonprofits and charitable organizations around the state. Oftentimes when someone dies and their estate leaves money to this nonprofit or charitable organization, and it's in a brokerage account or it's in some sort of financial institution, it takes a really long time to get those funds released. And so what this does, it creates a uniform, streamlined affidavit process and puts some guardrails in place that will speed up the timeline for which those funds will make it to the organization. Mr. Chairman, I'll take any questions.
Very good explanation. And Chairman, Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Chairman Boyd, or Whip Boyd, and I apologize, I haven't read the piece of legislation beforehand, but I'm curious, is there an estate opened up for the person that's passed away, then directs the charitable giving from a will, or is it something that they're directly? I guess I'm confused about the estate and what is the holdup to get the funds to the charitable organization.
And y'all are welcome to go back.
Okay, thank you, Mr. Chairman. I probably use the term estate loosely. This would be people that are the beneficiary on a brokerage account. It could be an IRA, it could be non-tax qualified money, or it could be deposit products at a bank. It's not really a problem with like life insurance or annuity contracts because the beneficiary is pretty straightforward on that. But on these, what we have seen is we have seen the financial institutions drag their feet, require specific forms to be filled out, then they want more. Then since it's going to a nonprofit or a charitable organization, they want the board of directors' social security numbers. And so these nonprofits that are entitled to the money because it's been left to them are oftentimes waiting up to a year just to get them to disperse the funds. And so this just says you can't do that anymore. You can't ask for unnecessary documentation. You need to make an attempt within 10 days of the death if you know about it to alert the organization. And then it creates more of a streamlined affidavit.
Good. That's what I'll make sure, because I don't mind saying out loud that Bank of America is one of the worst in this field to get access to funds. You have to go through 14,000 different bureaucratic procedures. And so to do this, but I want to make sure I'm clear that this does not include when an estate is opened up. This is if they're in a direct named beneficiary in a life insurance policy or qualified annuity or whatnot, where they're the direct beneficiary and it's taken way too long to get their funds. Am I understanding that correctly?
You're partially right. We actually amended out annuity and life insurance contracts for that reason. But the other things that you described, this is non-probate assets.
Great.
And that is my bad because I actually did use the term estate and I used it loosely and shouldn't have.
Well, that just triggered a whole lot of issues in my mind. So I appreciate the clarification, Whip Boyd. Thank you.
Thank you. And I appreciate the sponsor addressing the probate court issue on it too. So, all right, members, we're voting to send House Bill 2112 to Judiciary as amended. All those in favor vote aye. Those opposed vote no. Does every member voted? Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 2112 goes to Judiciary as amended. Next up, item number 5 is House Bill 2109 by Chairman Boyd. We got a motion and a second, and I do show an amendment.
Yes, Mr. Chairman, that's Amendment Drafting Code 013410.
We got a motion and a second on the amendment. We have a second going twice? And we got a second. All right, all those in favor of adding 013410 to House Bill 2109 signify by voting aye. Opposed, no. The ayes prevail. Chairman Boyd, you're recognized on the bill as amended.
Thank you, Mr. Chairman, and thank you for that second up there. You guys would have missed out on an incredible bill here. So this is the bill that I have entitled the Mercenary Rioting Bill. So what this bill would do, it would create civil liability for individuals and entities that pay demonstrators to participate in a protest if compensated if they commit certain offenses. Those offenses are things like riot, aggravated riot, disorderly conduct, obstruction of a highway, harassment, civil rights intimidation, civil disorder, and related crimes to that. The bill would also authorize the Attorney General to bring civil action in the public interest and recover cost and attorney's fees if the state prevails.
Very good explanation. And Representative Johnson, you're number 1.
Thank you, Mr. Chairman. So my question would be, I mean, I know that in the situation of January 6th, there were people paid to be there. But has there ever been any proof that that has been the case in Tennessee? Because I have never seen any proof or factual account of that being the case in Tennessee.
And again, you're all working with both for us.
Thank you, Mr. Chairman. And so we have never collected that data. Law enforcement has never been instructed to collect that information. And so most of the examples that we have are anecdotal in nature, but if no one is doing this, then there's nothing to worry about.
Okay, but so you're telling me you have no proof that this is a thing other than what we know about that was proof for January 6th?
So we've never had any law enforcement that we've asked to collect this information. So this is first of a kind legislation in Tennessee. So any data that would give proof of this, we've not asked for previously through law enforcement or investigative powers. So what this bill does is we're going to start checking into that. So if someone is arrested and they are being paid, then the financier will be held civilly liable.
And so who's going to be checking into that? Who are we creating a new office for this, or is it just going to be current law enforcement? That's another duty they're going to have. Who's going to be responsible for that?
It would be law enforcement through normal investigative powers. If someone is arrested under these charges and they find out that they were in fact paid, then it could be the Attorney General's office could actually be involved in it as well.
Okay, because I've heard members make the comment that that it's happening and there's proof, and again, no one has ever showed any proof. So I'm just curious about that. But thank you.
Thank you. Any other questions? Seeing none, we're voting on House Bill 2109 as amended. The full judiciary signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk takes a vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. Full judiciary as amended.
Thank you, Mr. Chairman of Committee.
Thank you. Next up, item number 6, House Bill 1456 by Chairman Bolzo. We have a motion and a second. Chairman, you are recognized, and I do not show any amendments.
Thank you, Mr. Chairman. Good afternoon, members of the committee. This is a bill that seeks to increase the limits of claims that are brought before the Tennessee Claims Commission. The Claims Commission Act was adopted back in 1984, and at that time, limits of $300,000 per claimant and $1 million per occurrence were put in place. In the 42 years since we enacted the Tennessee Claims Commission Act, those amounts have never been adjusted. This bill seeks to increase the $300,000 per claimant amount to $500,000 and the $1 million per occurrence amount to $1.5 million. And just for reference, if we were to use in the inflation factor from the Consumer Price Index, $300,000 in today's dollars is $950,000. And $1 million using Consumer Price Index in 1984 is now worth $3.2 million. So these increases are modest when one looks at the inflation adjusted value of money from 1984 through the present. And with that, Mr. Chairman, I'm happy to respond to any questions.
Thank you, members. Representative Garrett.
Thank you, Mr. Chairman. Chairman Bowles, I was just curious with the Claims Commission, who would this apply to? I've gotten some pushback that this might apply to local governments, and I don't believe the Claims Commission would, but I just want to make sure who would this apply to and what would the limits would increase, obviously, but who would that apply to?
And y'all are welcome to go back and forth.
Thank you, Mr. Chairman. It would apply just to the state and to state employees. Local governments are governed by a different statute, the Governmental Tort Liability Act, which this committee raised the limits on last year in 2025. That bill's still working its way through the General Assembly, but this just applies to the state and its employees.
Okay. That's all I've got, Mr. Chairman. Thank you. Thank you.
Representative Johnson, you're recognized.
Yes, and I just wanted to thank you for bringing the bill because I have constituents that really struggled with that amount, the lower amount, and this would make a huge difference for the rest of their life after.
Well, thank you, Representative Johnson. And this is a particularly good time to raise it because in just last year alone, there were 3 claims in 2025 that were settled at the $300,000 limit, where the claims themselves likely would have been settled above $500,000 had the limits been higher last year.
Yeah, I had a constituent who lost both her legs at the knee, and $300,000 was all she got. And that was some years ago, and she can't even get a wheelchair now because she doesn't have the money. Thank you.
Thank you.
All right, members, no other person signed up for questions. All those in favor of sending House Bill 1456 to judiciary signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. 1456 goes to judiciary.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. Next up is item number 7, House Bill 2012 by Chair Lady Littleton. We got a motion and a second. Chair Lady Littleton, you're recognized, and I do not show any amendments.
Sorry. Thank you, Mr. Chairman. This creates a civil action for individuals who are the subject of an intimate image that is intentionally disclosed without said individual's consent in certain circumstances.
Good explanation. Members, we got any questions for the sponsor? And Representative Johnson, you're recognized.
Yeah, I'm curious, what is maybe we have to go to legal for this. What is the definition of intimate image?
And you're all welcome to go back and forth, or would you like us to go out of
Yes,
session?
please.
Okay. Without objection, we'll go out of session. And legal, you're recognized.
Michelle Fogarty, Legal Services. This provides a civil action for a person who's a victim of the unlawful exposure offense, which is the distribution of an intimate image that was the image was taken with consent, but the distribution was without consent. So it's, the bill does define intimate image. I'm sorry, let me see. Where's it? The bill defines intimate image as a photograph, video recording, or social media broadcast of the intimate part or parts of an identifiable person or an identifiable person engaged in sexually explicit conduct.
Representative Johnson, you got anything else for legal or?
Well, not for legal, I don't think so. Well, let me go ahead and ask. I mean, this is such a weird question. You know, the people take these odd pictures of people and post them on, Women of Walmart or something like that. Could some of those be included as an intimate image?
Legal, you're recognized.
Would that be included?
So generally, for this offense, the image is recorded with or taken with consent between the two parties. It's just the distribution that is without consent.
Okay, gotcha.
All right. Anybody else got anything for legal? Seeing none, we'll go back in session. And Representative Johnson, you're recognized.
That's good, thank you.
All right, members, we don't have anybody else on the list, so we're voting to send House Bill 2012 to the judiciary. All those in favor signify by voting aye. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 2012 goes to judiciary. And next up, item number 8, House Bill 2352. We got a motion. We have a second. And Chair Lady Littleton, you're recognized, and I show an amendment.
Thank you, Mr. Chairman. Yes, Amendment 014201.
That's what I show. We got a motion, and we have a second on the amendment. All those in favor of adding 14201 to House Bill 2352 signify by voting aye. Opposed, vote no. The ayes prevail. And Chair Lady Littleton, you're on the bill as amended.
Thank you, Mr. Chairman. And this was brought to me by the AOC. Requires each juvenile court to report to the administrative office of the courts, the AOC, each new dependency and neglect case, along with supporting information on a monthly basis.
Very good explanation. Members, do we have any questions? Seeing none, for voting to send House Bill 2352 to judiciary as amended, all those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. 2352 goes to judiciary as amended.
Thank you, Mr. Chairman and Committee.
Congratulations. Next up, item number 11, House Bill 1660 by Representative McCowan. We had a motion. We got a second. We got a second, and Chairman McCowan, you're recognized.
Thank you, Mr. Chairman, and good afternoon, members. My mind is still in the morning. Members, what House Bill 1660 does is essentially protect our heritage of motorsports racing, protects existing racetracks that were established before surrounding development, prevents private nuisance lawsuits from being used to challenge lawful government-approved operations, and provides predictability so tracks can continue operating and reinvesting in their facilities. With that, I will stand ready for question. I do know we have some people, I think, signed up to testify. So if the committee would like to hear from them first, and then we can continue our discussion.
Thank you. Members, seeing No objection going out of session, or Representative Travis, you got something, or would you like to go out of
Yes, Mr.
session and hear from the witnesses first, or got a question
That'd be
for the
fine.
sponsor? or-
That'd be fine.
Okay. Without objection, we'll go out of session. And Christian Robinson and Norm Parton, if you'll come up. Yeah, right to either one. And if you'll tell us who you are and who you represent, you'll have 3 minutes. And then when you're done, Mr. Parton will go next.
Perfect. Thank you, Mr. Chairman. My name is Christian Robinson. I'm here with the Specialty Equipment Market Association and Performance Racing Industry. I thank you and the committee for the opportunity to testify today. SEMA and PRI represent thousands of small businesses involved in the automotive aftermarket and motorsports industry nationwide. Here in Tennessee, SEMA represents 129 member companies. These are manufacturers, engine builders, parts suppliers, retailers, and racing businesses located across the state. Their success depends on a healthy and stable motorsports ecosystem. Motorsports is a meaningful economic driver in Tennessee. The industry generates close to $3 billion in total economic output in the state, supports close to 11,000 jobs, and produces nearly $1 billion in wages and benefits for Tennessee workers. It also contributes $347 million in state and local taxes paid. These figures are not abstract. They represent real Tennessee families, small businesses, and communities that depend on racetracks and racing-related activity. HB 1660 provides a reasonable and balanced framework to protect racing facilities that were lawfully constructed and operating before surrounding development occurred. Too often we see situations where residential growth moves closer to a long-standing track, and then a nuisance claim threatens facilities that have operated responsibly for decades. This bill does not excuse unsafe or unlawful conduct. It does not give racetracks a blank check to operate. What it does is provide clarity and predictability so that established facilities are not driven out of operation simply because growth patterns have changed around them. When a racetrack closes, the impact extends far beyond the property line. Hotels, restaurants, fuel providers, part suppliers, and local retailers all feel the impact. In many cases, once a track is lost, it's gone permanently. Tennessee has a proud motorsports heritage, from grassroots short tracks to nationally recognized venues. HB 1660 helps ensure that this tradition continues while projecting jobs, investment, and the economic contribution racing brings to communities across the state. On behalf of SEMA, PRI, and our 129 member companies in the state, I respectfully urge your support for HB 1660. I'd be happy to answer any questions you may have.
Thank you. We'll go to Mr. Parton. If you'll just say who you are and who you represent, then we'll come back for any questions.
Thank you.
And you'll have 3 minutes also.
I'm a Nashville native, by the way, born and bred here. He mentioned the people that are impacted, but there are people that race. Some people have bass boats, some people play golf, some people go skiing. They invest in that. Racers invest hundreds, thousands, and millions of dollars. And when you take away their venue, their racing equipment becomes a boat anchor. This includes 8-year-olds that race the Bandolero Series. You've got teenagers that race the Legend Series. In a case in point, just in Nashville, Tennessee, Josh Berry, who has won on the NASCAR Cup Series, got his start at the Nashville Fairground Speedway as a Legends champion. If not for this breeding ground of talent, we would not have Darrell Waltrip. People like that come through this system. There are 8-year-olds out there now racing. Tonight, they will be underneath their race cars preparing for the season. So people have investments. If you took away golf courses, there would be a riot. If you took away the lakes from fishermen, there would be a riot. The racers deserve the same consideration. You take their venue, what happens next? You put them out of business, their investment becomes nothing. Racing is a generational sport. There are many people racing today that their grandfathers raced, that their fathers raced, that their uncles raced. It is generational, and if you close racetracks, you take that away from people. You're stealing their golf, you're stealing their fishing, you're stealing what people do. And it's only right to protect the venues, to protect those people who spend thousands of dollars. Middle Tennessee alone and pro late models represents about $26 million worth of equipment, shop, tow trucks, engines, tires. $26 million that people pay taxes on. So they deserve to keep their venues available for them.
Very good testimony. Members, we have any questions for the witness? Representative Johnson, you recognize?
Yes, I think you gave a number of facilities. It was 120 or 30 something.
And
That's the
y'all are
number
welcome to
of
go back and forth.
member companies that Seaman PRI have. The number of tracks in the state is 22.
Okay, so based on what you were just saying, how many tracks have been closed down? Because I didn't think anybody was talking about closing down tracks. How many tracks have been closed down, say in the last 10 years by local authorities because of regulations?
I can't think of any that have been closed because of regulations. The problem is people, and I will give you an example of the fairgrounds in Nashville. I was born in 1953, lived a block and a half from the fairgrounds. The very house that I was born in, the person putting up the biggest fuss to close the fairgrounds lives in that same house. I don't know how the gods made that happen. People have lived there, and I have personally toured the neighborhood, talking to people surrounding the fairgrounds. I can tell you with authority, 80% could care less about the racetrack. They want it redone. They want it improved. They want it better. You've got people with their hair on fire trying to close racetracks, and it's going on nationwide. And this goes on in small counties and in big cities all across the country. And this is to protect the people. We race. We race, and we have to have a place to race. And if you take that away, you're hurting people when you have people that moved into a neighborhood on a track that's been in existence for longer than anyone in this building was born. And they're trying to close it. That's the purpose of this, to protect us that race and our kids and future people that want to race. If not for local racing, we wouldn't have Jeff Gordon. We wouldn't have Darrell Waltrip. It has to protect these people. That's the only place they have to go.
Right, and it sounds like it's it's not under attack because nothing has closed, and so I've probably been to a handful. I'd probably count on one hand the number of races, but I have a lot of friends who are race fans,
Yes.
and I understand that's it's a large group of people. However, what my concern is when you take the locals' ability away from, especially when the local government can't regulate that, where do people who have a concern go to remedy their complaints if they can't go to their local government?
The local government dictates what happens as far as curfew times, number of events, the decibel readings. All of these things come into place, and all of these tracks comply with local regulations. I can speak very carefully about the fairgrounds in Nashville. Some of these other tracks out in surrounding areas I'm not as familiar with, but the local fairgrounds Nashville is under attack by people that moved here, and now they want to close something that's been here before they were born. So what's fair? If you are under regulation, you're running curfews, you're limiting number of events, the decibel readings are there. Local government and county governments have that ability to dictate that. So it's not like they're running wild out there.
But for certain people, they won't. So that's just my concern. But thank you. I appreciate your answers.
One more point.
Sure.
So I bought an office building in Brentwood, Tennessee. So I had to make a decision to invest. This is $1 million purchase of money that I didn't have. I am 36 yards away from the L&N lines that leave Radnor Yards. 36 yards away. We could not have this conversation in my parking lot. 200 yards that way is I-65, 24/7. And so you have to look at, I'm a big boy and I accept, and I'm not going to lay on the tracks and say you can't run a train down here. I accepted that. That train track was there during the Civil War. So it becomes a matter of fair.
Very good. Representative Senate, you're next.
Thank you, Chairman. Mr. Pardon,
Yes.
I was coming to that speedway in the late 50s. Been coming. I've also been in business with Smoky Mountain. 411 is closed because of public pressure. Board Speedway in Chattanooga, is across the line from into Georgia, is closed because of a subdivision. And also Cleveland Speedway is closed. So those are the three that I know of in East Tennessee that have closed. And there's more, but all three of those are closed because of public pressure and
Yes.
Development. So I'm all about the history of Nashville.
Yes.
And all the folks seeing Marty Roberts get out of the car and jump out so he could make his get to the Grand Ole Opry because the race was running along was a memory that I won't ever forget.
Correct.
Thank you for your testimony. Thank you, Chairman.
Thank you. We appreciate y'all being here today. Without objection, we'll go back in session. And Representative Travis, you're first on the list.
Thank you, Mr. Chairman. And I too do not want to close a racetrack. 1972, I got to drive a couple races in a race car on a dirt track. So I'm not against racetracks at all. But it's come to my attention, and there's a lot going on with this bill that I would suggest to the committee that we do a true summer study on this and try to figure out both sides and see where this is going. So my motion is that we'll send this to summer study.
That's a proper motion, proper second. Does the sponsor have anything to add?
Mr. Chairman, I'm at the will of the committee. I was happy to answer any additional questions based on their testimony, but again, I am at the will of the committee.
We appreciate your advocacy on this. We appreciate your witnesses or the witnesses that are here to testify. It's an important issue, and we want to make sure that we study it and do it right. So, all right. Without objection, we're voting to send House Bill 1660 to summer study. All those in favor vote aye. Those opposed vote no. And we're on the board. Has every member voted? Does any member wish to change the vote? Mr. Clerk, takes vote.
Mr. Chairman, you have 5 ayes, 1 no.
All right, House Bill 1660 goes to summer study. We appreciate you, Mr. Sponsor. Thank you. All right, we're going to skip around to item number 21, House Bill 2451 by Representative Garrett. Do I have a motion? We got a motion and a second, and Representative Garrett, you're recognized on 2451.
Thank you, Mr. Chairman. This piece of legislation has been brought to me by the Tennessee Bar Association, and it does 3 things. It clarifies in the Tennessee Uniform Partition of Heirs Property Act that real estate that needs to be brought back into the estate to pay for certain bills does not apply under that act. The second portion is that when you construct a will, or if you don't have a will, the only person that you cannot disinherit technically is your spouse. If you do, or if your spouse somehow is not included in your estate, they can elect what's called an elective share. And of course, that's derived from a lot of inheritance tax law, et cetera, that's been updated and changed. So we're just mirroring that with the federal law to update how we calculate the elective share for the spouse that makes that choice in the event their spouse passes away. The last section also is regarding conservatorship petitions, and we're making some of the length. Right now, the way the code is written, the identifying information inside a conservatorship is actually not mandatory to put into the code. We're actually making that mandatory, which just identifies the ward, the potential conservator, the potential ward, et cetera, all identifying information, stuff that's not subject to public domain, of course, but it just makes that information mandatory. So with that, I'll be happy to take any questions on this piece of legislation.
Very good explanation. Members, we got any questions? Seeing none, we're voting to send House Bill 2451 to judiciary. All those in favor signify by voting aye. Those opposed, vote no. Does any member wish to change their vote? Mr. Clerk takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. 2451, judiciary. Next up is the objection will pull up number 19, House Bill 2034 by Representative Harris. We got a motion. Do we have a second? Need a second going twice. Third and final call for a second. Representative Harris, you're recognized on the bill as no amendments.
Did you say House Bill 2035, Chairman?
2034.
2034, okay. Thank you. Thank you, Chairman, and to the members of the committee. House Bill 2034 gives our municipal courts a practical and responsible tool to address property blight when property owners fail to comply with local code. This bill enhances code enforcement by allowing a municipal court to order that negative property be cleaned up by the city when necessary. This bill is, I'm just carrying it for Senator Taylor, and it is for violation of municipal orders. So with that, I ask for a possible recommendation.
Very good explanation. Members, we have any questions for the sponsor? Seeing none, we're voting to send House Bill 2034 to judiciary. All those in favor signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 6 ayes, 1 no.
The ayes prevail. Judiciary, congratulations. Next up, don't go anywhere. Item number 20, House Bill 2035 by Representative Harris. Do I got a motion? Do I have a motion? We got a motion. Do I have a second? We got a second. Representative Harris, you're recognized on the bill.
Thank you, Mr. Chairman and committee. House Bill 2035, if passed, would create in the 30th Judicial District 1 additional criminal court. In 2024, Shelby County lost 2 judicial seats, 1 in criminal court and 1 in circuit court. Senator Taylor and I, along with every member of the Shelby County delegation, as co-sponsors of this bill, are asking at this time for the support of the legislature in adding 1 criminal court division to the 30th Judicial District. The 2026 Tennessee Judicial Weighted Caseload Study released in February of 2026 lists the 30th Judicial District in the top 10 greatest 3-year average deficit in judicial resources. I want to thank the AOC comptroller and the governor's team in the multiple meetings and discussions. And I asked the committee for a positive recommendation to move this to full judicial committee.
Very good explanation. Members, we got any questions? Representative Johnson, recognized.
I just want to say thank you because I'm a Knoxville rep, but I even heard from Memphis judges, saying, please, we really need help on this. So thank you for bringing this. It's important.
And Chairman Farmer, you're recognized.
Representative Harris, just curious, do you know how many criminal court judges there are in Shelby County?
This will add a 9th criminal court.
So this will be the total of 9 criminal court judges?
9 division.
Do you know how many state court judges in Shelby County that hear civil cases only?
I don't know that number exactly, but I can get that information for you.
Okay, but you agree that you're asking for a 9th judge to hear criminal cases only? That's your request?
Yes.
Okay, thank you.
Thank you. Members, I don't show anybody else for questions. First voting to send House Bill 2035 to judiciary. All those in favor signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. Judiciary, congratulations.
Thank you so much. I appreciate you all.
You're welcome. Next up is Give me back where I started from. Item number 12, House Bill 1835 by Chairman Hicks. We got a motion and a second. Let me just clarify that is House Bill 1837, and you're recognized to describe the bill.
Thank you, Mr. Chairman. I think I've got an amendment, 013797.
All right, we got a motion and a second on the amendment. 13797. All those in favor of adding House Bill 13797 to House Bill 1837 signify by saying aye. Those opposed, vote say no. Amendment's added. Congratulations, and describe the bill as amended.
Thank you, Mr. Chairman. Thank you, members. Members, this legislation is about one simple principle, fairness. When a citizen purchases property, they do so under a specific set of rules. Those rules determine what they can use the property for, how they can divide it, how they can sell it, and ultimately what it's worth. If government later changes those rules in a way that reduces the fair market value of the property, this bill says government must either compensate the owner for that loss or restore the use that was permitted at the time of purchase. This does not eliminate zoning. It does not weaken health and safety laws. It does not touch fire codes, building codes, sanitation, traffic and pollution control, or regulations required by federal law. Those protections remain fully intact. What this bill does is prevents one family from being forced to shoulder the financial burden of a policy decision that benefits everyone else. There is a written demand required. There's a defined time frame. Government has the option to modify or waive the regulation instead of paying the compensation. It encourages resolution before litigation and promotes responsible rulemaking. At its core, this legislation reinforces a fundamental principle. If government action takes value, government bears the cost, not the individual property owner. I respectfully ask for your support of this bill.
Very good explanation. Members, we're going to go out of session without objection. Hear from a witness, Mayor John Edwards. Mayor John Edwards, and without objection, we'll be out of session. And Mayor, if you'll just say your title, who you are, and where you're the mayor of, you'll have 3 minutes.
Yes, sir. I'm John Edwards, the mayor of Cedar Hill in beautiful Robertson County, Tennessee. I think it's one of the greatest counties in Tennessee, but I'm biased. So I wanted to start off, and I'm going to end with this quote as I'm going to start with it. Thomas Jefferson said, "The government that's closest to the people serves the people best." What this regulations and this proposed bill would do is it would hurt local government, local counties, local municipalities' ability to manage growth, which is ever changing. We're one of the fastest growing states and regions in the United States right now. And so with that, as we grow, we have to come back to the drawing board and make citizens change that benefits our county as a whole. And sometimes with growth, that may involve setbacks. It may involve changes we have to make with infrastructure. We can't put the cart before the horse. And what this way it is now is we are allowed to make common sense changes that defend our folks from irresponsible growth. A key point to responsible growth is for your local legislators, your local municipalities, your local counties to manage growth and make decisions as for a whole. And that's exactly what this is. As a conservative, I'm as big of a proponent for land use rights as anybody, but I also understand that our government, as me as a mayor, we are responsible for doing what is best for not only our citizens, but also our physical health as a county and municipality. So again, as I finish that, I remind you, we are the government that is closest to the people, and we know how to serve them best. And thank you so much.
Thank you. And Representative Johnson, you're first on the list.
Thank you. And I appreciate you being here because that's what I had in my notes. This seems anti-local government. And so I'm glad that you were here to speak up and verify what I was thinking and any questions that I had. So I appreciate that.
Yes, ma'am. Thank you.
Very good testimony. Thank you for being here. We don't have anybody else on the list.
Thank you
Without
so much.
objection,
Thank
we'll go
y'all.
back in session. Any questions for the sponsors? Seeing none, we're voting to send House Bill 1837 to judiciary as amended. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 2 noes, 1 present not voting.
The ayes prevail. 1837 goes to judiciary as amended. Congratulations.
Thank you, Chairman. Thank you, committee.
Thank you. Next up, we're going to take this one out of order. Number 18, House Bill 2585 by Representative Chisholm. We got a motion and a second, and Representative Chisholm, you're recognized. Describe your bill.
All right. Thank you, Mr. Chairman. Thank you, committee. House Bill 2585. So under current Tennessee law, non-economic damages are generally capped at $750,000. This legislation does not remove the cap, but the bill does, however, create an adjustment by increasing the cap to $1 million in healthcare liability cases involving obstetric or maternity negligence that result in the death or permanent injury of a pregnant or postpartum woman. With that, I stand by for your consideration.
Very good explanation. Members, got any questions? Seeing none, we're voting to send House Bill 2585 to judiciary. All those in favor vote aye. Those opposed vote no. Has every member voted? Does any member wish to change the vote? We're voting. All right. Mr. Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 1 no, 1 present not voting.
The ayes prevail. Judiciary, congratulations. Next up is, let's see, who is this? Oh, number 13, Chairman Halsey. We had a motion. Do we have a second? House Bill 2037. Do we have a second? Going twice. We got a second. Chairman, I show 3 amendments. Which one would you like?
I just need 2 of them, Mr. Chairman, and thank you. I need 014231 and 014245.
All right, members, we got a motion on, we'll take the first one as 014231. We got a motion and a second. All right, all those in favor of adding 2037 or 14231 to 2037 signify by saying aye. Those opposed say no. Amendment added. What's your next one?
014245.
Okay, those in favor of adding 14245 to House Bill 2037 signify by aye. Opposed no. The ayes prevail. All right, that is added, and I believe we got to do roll. All right, members, without objection, we're going to roll both amendments into one. All those in favor signify by saying aye. Opposed, no. The ayes prevail. All right, Chairman Hosey, you're recognized on 2037 as amended.
Thank you, Mr. Chairman. I don't like being number 13 on the calendar, but I'll take it anyway. So I appreciate the committee and your indulgence. This is called the Tennessee Just Compensation for Property Owners Act. It deals relative to eminent domain used by airport authorities. And what it does is it ensures just compensation for people who lose their property by eminent domain. If an airport doesn't use eminent domain, this bill doesn't apply to them at all. This just applies to airport authorities or their designees who use eminent domain to remove private property. And what it does is the property owner selects an appraiser, and the condemner pays the cost of the appraiser. The property owner obtains at least 3 estimates. Oh, by the way, when the appraisal comes in and they settle on the appraisal, the owner will be paid 1.5 times the appraised value of the property. The condemner pays the damages based on lost wages or lost profit from a business. When it comes time to move, they get 3 estimates from movers or contractors that move, and the condemner pays the cost of that. The condemner pays damages for increased interest expense for if you had your house financed for 2.5% interest. Now you've got to jump to 7.5 or 8. They pay the difference in that. And then if they decide they don't want the property or it can't be taken, they pay attorney's fees also. Now, some people read this as being harsh, but there's a difference in airports taking property by eminent domain and regular eminent domain. Regular eminent domain is used for a public use, a road, a railroad track, a bridge, a school. And airports take property by eminent domain. It's not used for that kind of public. It is used for a private entity. In fact, the only thing owned by an airport actually is the runways, the terminal, the control tower, and an FSS station if there's one there. Everything else is private. The hotels are private. They pay lease payment on. All the avionics shops that repair radios are private. The A&P mechanics are all private. The warehouses that hold executive jets are all private. So property around an airport, other than the extension of a runway, and they own the runways, goes for a private property type use. So it's bad enough to have your property taken away from you by eminent domain for public use. It's another thing to have it taken away when it's going to be used to generate revenue in a private setting. So this bill just offsets that pain by making an airport authority pay more money. And that's the gist of the bill.
Very good. Members, we got two people that wishes to testify. Any objection going out of session? Without objection, we'll go out of session. First, if Aaron Eslinger will come down, and you'll have 3 minutes. Just give us your name, who you represent, and we'll start the timer.
One second. Good afternoon, and thank you, Mr. Chairman. My name is Aaron Eslinger, speaking in favor of HB 2037. Invoking public purpose does not justify undercompensating individual property owners for airport expansion. Airports already recover their operating and capital costs through user fees, airline rent, parking revenue, and federal grants. This legislation simply requires that the true cost of land acquisition be accounted for upfront rather than shifting onto a small number of displaced owners. In May of 2023, I met with Mr. Schroth of McGee Tyson Airport to discuss the airport expansion and why they are interested in buying houses in our neighborhood. In my neighborhood. He explained that our neighborhood would not be needed for the new expansion, but he wanted it. Mr. Schroth said that they would be looking to have bought up my neighborhood over the next 10 years. I then asked him if they intended to use eminent domain to acquire the properties. His answer was, no, we would just condemn them. These property owners will want to move when they see what is coming into the neighborhood. He also told me that they intended to put the homes on the market to rent after they bought them. Of the 18 airport acquired properties that I know of, only 3 are rented and 2 are to previous owners. The rest stay vacant, dilapidating, as one property has a pool and is a breeding ground for mosquitoes. When an airport targets a neighborhood, they use tactics to intentionally devalue surrounding property. Fair market value is grossly damaged. This is one of the elements this bill helps to reconcile. Cost and delay are not defects of this bill. They are the price of constitutional compliance. Airports may take private property only upon payment of just compensation, not discounted compensation achieved through dark tactics such as coercion, unfair leverage, or litigation fatigue. This bill does not prevent airport expansion or safety improvements. It simply requires airport authorities to internalize the real economic harm their projects impose on individual property owners. If a project cannot proceed while fully compensating those it displaces, the problem is not the compensation standard, it is the project's true cost. We worked hard on this bill to protect the equity of property owners in the shadow of powerful airports. To quote our beloved Congressman Tim Burchett, folks, we got to do better. Please vote yes for HB 2037. It's the right thing to do. Thank you for your time. And if you have any questions, I'd be glad to answer.
Very good testimony. Seeing no questions, we'll call up the next person, and we appreciate you being here. All right, next up is Doug Crulin. And I hope I pronounced that correctly. And Mr. Crulin, you'll have 3 minutes if you'll just say your name, who you're with, and we'll start the timer when you begin.
Okay, thank you very much, Mr. Chairman and members of the committee. My name is Doug Crulin. I am President and CEO of the Tennessee Association of Air Carrier Airports, which is comprised of the 5 commercial airports in Tennessee: Nashville, Memphis, Knoxville, Chattanooga, and Tri-Cities. I'm also the President and CEO of the Nashville International Airport. I'm speaking today in opposition of Bill 2037, titled Tennessee Just Compensation for Properties Act. For multiple reasons, the bill sponsor mentioned, this is for public use. The airports authorities, all 5 of them are public airport authorities. They're not private businesses. The airport authority in Nashville owns all 4,600 acres of our property. We all own all 300 acres of our property at John C. Toon. Same for Memphis, same for Knoxville, Chattanooga, and Tri-Cities. We are public creations of the state of Tennessee trying to build the infrastructure necessary for Tennessee to continue to grow. This bill is not the right thing to do. And the background on eminent domain is airports rarely have used eminent domain. The last one we can find is 41 years ago in Knoxville, but it wasn't by the airport, it was by the city of Knoxville for something they wanted to do. Any use of eminent domain by airport authority is governed by 2 of the 3 documents I brought here. First is a federal document from the U.S. Secretary of Transportation, 49 CFR Part 24, 84 pages of instruction. And then you push it down to advisory circulars from the FAA, 150/5100-17, 148 pages. And then there's 40 additional grant assurances because all 5 of the commercial airports receive federal fund. If we violate any of these regulations, they stop federal funding and they could actually require us to pay back federal funding we've received previously. Federal law has substantial protections in all of these documents. And because of that protection for the homeowners, we rarely use eminent domain. I've never used it. We don't want to use it because it brings you to the front of the public. But if you just look at the table of contents, and I can leave these documents for the advisory circulars that the airport authority would have to follow: Chapter 2, real property appraisal; Chapter 3, real property acquisition; Chapter 4, relocation assistance; Chapter 5, payments of moving and related expenses; Chapter 6, replacement of housing payments; management of acquired property. All of these federal rules, if we don't follow them to the letter, we lose federal funding, which is significant to all 5 of the airports. The bill references in the recitals, the U.S. Constitution requires fair compensation or just compensation. This federal document.
Mr. Corinne, that's your 3 minutes. Members, we got any questions? Representative Garrett, recognize.
Thank you very much, Mr. Chairman. You were about to make a comment because I think it's going to relate to the question that I had. Could you finish your thought there on the compensation piece? I think where you were heading.
U.S. Constitution requires just compensation for acquiring property. The federal guidelines use the term fair. This bill is mislabeled because it says just compensation when the actual words that are used are enhanced compensation. If we pay 150% of the fair market value, I'm in violation of federal standards. I lose funding for Nashville, Memphis, Knoxville, Chattanooga, and Tri-Cities.
All right, Chairman Don, you're recognized.
Thank you, sir. Mr. Crulin, you mentioned about, and I think you were clarifying in the last part of the sentence you used related to airports not using eminent domain. It's actually the governing authority, like the city of Knoxville, I think the example you gave. And so in that example or that point you were making, so of the airports that have been mentioned, have any of them, other than the instance you mentioned in Knoxville, utilized eminent domain for their corresponding airport in the last several decades?
No, and it was several, what's the definition of that? But I've checked in the last 41 years, none of us have used it and none of us have anything on the books where we're contemplating eminent domain. The comment reference of Knoxville purchasing land, we have homeowners that reach out to us all the time. Hey, I'm east of the Nashville International Airport. My mom passed away. Nobody wants the house. Would you like to buy the piece of property? We're able to buy that piece of property and comply. We pay fair market value for that. We don't pay 150, but we've never gone, not in my 14 years here, and tried to, take a property by eminent domain.
And y'all welcome to go back and forth.
Okay. The only other question I had is related to what you mentioned about the federal grants and funding. So if this bill were to pass as it is, that 150% would definitely disqualify you from some of those federal funds, or possibly, what would be the right adjective there?
It would, per the way that they're written today, we would not be able to pay those because we would be in violation of federal, regulations from US DOT, FAA regulations in terms of the advisory circulars and the grant assurances that we have to sign for every grant that the federal government gives us. We could not say that we were paying fair market value, but we would not be able to, we would be in violation of another grant assurance that would be revenue diversion because I'm paying more than that property is worth.
Thank you, Mr. Chairman.
Thank you. Seeing nobody else on the list, we'll go back and Chairman Farmer.
Yeah, just had a couple of questions with regards to these. There was some comments made about how these airports are making money.
Correct.
Off of leased properties. Can you walk us through that? Because I've been in a national airport. I've been in Knoxville just here recently as well. There's restaurants and all those airports. There's shops and things. How does that work with regard to does the authority at least to those folks? Where does that money go that they're paying? How's that work?
Sure. The airport authority, per these rules and regulations, grant assurances that I'm describing to you, every dollar that we make on the airport authority has to be reinvested in the airport authority. I'm not allowed to pay for something downtown or in some other location. We make money three ways. The airlines pay to land on the runway, park at the gate, and rent space for you to get on and off. That's one. Second is parking and concessions. We charge for parking. The concessionaires that sell hot dogs, hamburgers, and Diet Cokes give us a percentage of their revenue through the rent that they pay us. But we own that. And then that's it. Parking, concessions, and the airlines.
Mr.
You're welcome to go back and forth.
Yes, sir.
In regards to the grants, the matches you get from the federal government, one of my concerns is this. I know that as I go through our airports, travel out of Knoxville a lot and BNA quite a bit, we have good security there. The machines, sometimes you just walk right through them or you stand up, it scans you. It seems like to be very top of the line technology there. With these grants, if we lost these federal grants, could that affect the security of our airports? Having those machines, or is that something, or is that funded separately? How's that work?
So that is funded through the TSA bucket of money. So that's a federal agency working inside on our property. Same, the tower is an FAA organization working on our property, and same way with customs. So any loss of federal funds to us prevents us from building or improving. Right. And then any loss of funding to either one of those three agencies jeopardize our ability. But if we're in violation of any of the federal rules and regulations, then it's what does the U.S. Secretary of Transportation send to us in terms of we're going to hold this until you get into compliance with the rules and regulations.
Okay. Thank you, Mr. Chairman. That's all I have. Thank you.
Thank you.
Thank you. Seeing no further questions, we appreciate you being here today and your testimony. Without objection, we'll go back in session. We've got 8 minutes, so questions for the sponsor, and Chairman Todd is up.
Mr. Chairman, I have a permission or notification for Mr. Seal that he filled out and was granted to speak.
Yeah, so he testified last week. You can only testify one time. So
Okay, all right. All right, thank you.
thank you. Chairman Todd, you recognize.
Chairman Halsey, I just had a question. The 150% is a little bit of a hangup for me, even before Ms. Crewlin told me about the grants and the other federal funding that they rely on and how that can be jeopardized. So with all the other things you have in the bill that seem pretty reasonable, like compensating for the interest rate if they had to have a higher interest rate on their mortgage, a lot of those things seem very reasonable, but the 150% just does not seem reasonable. Is that done anywhere else in law? Do we offer that anywhere else in eminent domain concerns, anywhere else that you know of?
I'm not certain in terms of eminent domain. I do not know. Of course, if you read those rules and regulations that this gentleman spoke of, and he's right about those, except these are floors. They expect states to go beyond that. And the states who have gone beyond that, maybe not to 150%, 1.5% on property value, but Alaska, California, Connecticut, Florida, Minnesota, Oregon, New Hampshire, North Dakota, Texas, and Wisconsin all have added enhanced abilities to pay more money when you take people's private property away from them. Of course, they said in 41 years this never happened, so there's no issue with them. They've got every right to purchase property from people who are willing to sell it, but this just deals with the event of using eminent domain.
Thank you.
Thank you. And Chairman Farmer, you're next.
Yeah, Chairman Halsey, I appreciate you bringing this piece of legislation up. I've got a question, though. I had, as I was thinking through this, I was looking at it from a 10,000-foot view. What makes the properties around airports more valuable than other places? What makes their house more valuable than my house if it's subject to eminent domain somewhere else? Why not make this apply to anyone who's subject to eminent domain? It doesn't seem fair to me that their properties are worth more than my property would be if a governmental entity of any sort comes by and wanted to take my property.
And it's a fair question. The only difference is they're going to put a bridge where your property is for public use. This will have a hotel or another hangar for UPS or a private corporation with a jet's going to pay least money for that.
Mr. Chair.
Yeah, we're welcome to go back and forth. So.
But you would have to agree that that's not a certainty. You'd have to agree that it could be for a runway, which would be essentially the same thing as a bridge or a road as well, right?
That'd be the only difference. What brought this to light was two neighborhoods right next to the airport in McGee-Tyson, of which this one lady lives. That neighborhood is slowly being purchased out, but there was another meeting where some of the folks representing McGee-Tyson were alleged to have used the threat of condemnation or eminent domain if they didn't sell. So that's how this all started, and that's how I ended up with this bill.
That's all I have, Mr. Chair.
Thank you. Representative Travis, you're next.
Thank you, Mr. Chairman. I call previous question.
Question's been called. Seeing no objection, we're voting to send House Bill 2037 to the judiciary. All those in favor signify by voting aye. Those opposed vote no. Does every member voting? Does any member wish to change their vote? Mr. Clerk, takes a vote.
Mr. Chairman, you have 2 ayes, 5 noes.
The noes prevail. Bill fails.
Thank you, committee and chairman.
Thank you. Next up is, I'm going to do a little cleanup first. Without objection, item number 15, House Bill 1707, road 1 week. Item number 16, House Bill 849, road 1 week. Next up is item number 22, House Bill 2174 by Chairman Travis. We got a motion and a second, and I show an amendment.
Thank you, Mr. Chairman. This bill is amended. It's amendment. It's traveling with 014249.
Okay, we had a motion, and then do we have a second on this? And we got a second. All those in favor of adding 14249 to House Bill 2174 signify by voting aye. Those opposed vote no. The ayes prevail. Representative Travis, you're recognized on the bill as amended.
Yes, sir. This amendment, it allows current and former judges to carry a handgun or weapon inside a building in which judicial proceedings are in progress or not in progress with equivalent training.
Very
for
good
handgun
explanation. Any members got any questions? Representative Johnson, you're recognized.
I think we talked a little bit about the training. It was the extended training, right? It was like the 40 some days or hours, maybe. What was the training?
No,
You're recognized.
Okay.
Y'all can go back and forth, actually.
yeah, Representative, it is equivalent to a handgun permit that we have now. It's equivalent. It's enhanced handgun. Yeah, we'll
Okay.
put the extra training on. They have to do, next year, they'll have to do another class of training to carry
Okay.
an arm.
All right, thank you.
And just as a sponsor, if there's any question, you'll work with the committee for an amendment if we need to add one before full.
That is correct, Mr. Chairman.
Thank you. Seeing no other questions, we're voting to send House Bill 2174 to judiciary. All those in favor signify by voting aye. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 2174 goes to judiciary as amended. All right, members, I do not show anything else. Everything on the calendar is taken care of until next week. Thank y'all for another successful meeting of the Civil Justice Subcommittee. See y'all same place, same time next week.